Today I bid to Dr. Sam. I'm Wong Yen Yang, metric number 280263. We are from Group 7, and today we would like to cast a light on the topic in regards to immoral, irreligious, seditious, and obscene works under the copyright law in Malaysia. Generally speaking, there are various types of works that can be copyrighted under the Copyright Act 1987. According to Section 7, subsection 1, paragraph A until paragraph F of the Copyright Act 1987, it was specifically provided that with the eligibility of the works to be protected under the law, which is comprises of literary works, musical works, artistic works, films, sound recordings, as well as broadcasts. Yet, this law, Copyright Act 1987, did not specifically regulate the copyrightability of the immoral, irreligious, seditious, and obscene work in this registration. These types of work are directly connected to public policy and morality. We will discuss them in depth below.
Good day, my name is Dashira and my matrix number is 280519. I will be explaining regarding the copyrightability of immoral work. In order to understand regarding the copyrightability of immoral work in depth, firstly, let's look into the definition of immoral work. Immoral means violation of moral law, norms or standards. So, immoral works means work which is conducted against accepted moral or ethical principle. The court, in the case of Venus Adult Shops versus Fraser Site Holdings held that immoral works are works that offend against community values or standards. Now, before discussing about copyrightability of immoral work in Malaysia, let's look at the general idea of it. Firstly, in the US, immoral works were not copyrightable, but after 1979, the position changed, where all the original work of authorship fixed in tangible medium are eligible to be copyrighted. However, the current position is unclear. On the other hand, in Philippines, immoral works are not eligible for copyright, unlike in France, where the law does not deny the copyright to immoral work. Moving on to the legislation of immoral work in Malaysia. Before going further into it, I would like to firstly mention that in Malaysia, there are no express provision, statute, or even act that governs immoral works. The act that might come handy while discussing immoral works are Penal Code and the Copyright Act. Even though this act might be of help, there are still no express provision in them regarding the works eligible for immoral work. Section 268 of the Penal Code discusses about public nuisance, which might implicitly be interpreted and related to immoral works. Copyright Act, on the other hand, only discusses about works eligible for copyright under Section 7 and works that are restricted to be copyrighted under Section 7, subsection 2A. Copyright Act is, however, silent on matters of immoral work. One main disadvantage of the lack of governing statute is that this implicit interpretation might not be applicable when the circumstances differ. There are a few suggestions from my side for the copyrightability of immoral works in Malaysia. Firstly, the laws should be amended to provide clearer guideline of immoral works and whether or not those immoral works are protected under copyright. These amendments should expressly define the type of immoral works and also the punishment or penalty that would be given to those who generate such works. And such amendments may be made to the Copyright Act. In my opinion, immoral works should not be copyrighted. I am of this opinion because immoral work causes bad influence on others, which has the potential to disrupt the society and nation's peace and harmony. Therefore, immoral works in Malaysia should not be copyrighted in order to avoid ambiguity and also to protect the society and nation from being disrupted. That's all from me. I would now like to pass on the presentation to the fellow presenter. Thank you.
Thank you. And let's further discuss about the copyrightability of irreligious work in Malaysia. According to the Cambridge Dictionary, irreligious means having no interest in religion and generally opposed to religion. In other words, irreligious means what is against religious belief and its practices. However, in the copyright law context, it can refer to any irreligious work which is against any religion and the works which show disrespect for any faith. There are few of the relevant law that can be referred to in discussing the irreligious works in Malaysia. The relevant legislations are the Copyright Act 1987, Censorship Act 2002, Penal Code, Communication and Multimedia Act 1998, and the Berne Convention. Section 7 and 8 of Copyright Act 1987 listed the works that are eligible for the protection. However, the Act is silent on the irreligious work, which is against the public policy. In sum, the Copyright Act 1987 only protects the work that was covered under the Act but silent on matter of irreligious work. Furthermore, Section 5 of the Censorship Act 2002 specifically covers the prohibition on the distribution, possession, exhibition of obscene films, among other things. However, there is no particular provision that mentions any films regarding irreligious content in it. Certainly, the Act only laid out provisions for obscene and not for irreligious work. Moving on, Penal Code did provide some rule and punishment for making an irreligious work in Malaysia, even though the Copyright Act 1987 itself did not provide any provision regarding the irreligious work. This can be referred to Section 298 capital A Clause 1 of Penal Code, whereby it is an offence if any person attempts to create disharmony, disunity, feelings of enmity, hatred or ill will through words, either spoken or written, on the matter of religion. The word spoken or written can be interpreted as any work produced, either books or films, which fall under the context of copyright work. In other perspective, criminal charge may be brought against anyone who create this work and request protection for it. In further discussion, Section 233 Clause 1 of Communication and Multimedia Act 1998 provides that any person using any of the work facilities and network service make or create any comment, request, suggestion, or other communication that is offensive in character with intent to harass or annoy is an offence. For instance, if a person makes a irreligious poetry using the network service with intent to annoy others, the person is subjected to this provision. Concisely, the Act did not protect the irreligious work, which is offensive and created using any word service, and in fact, the Act provides the punishment for the subject matter. Besides the Article 10 of the Berne Convention, copyright of sensitive or religious work is permitted as long as it does not directly conflict with union laws. This means that copyrighting this work is permissible as long as applicable national laws do not prohibit it. Therefore, it can be seen that the Convention did provide and allow the protection for religious work, but was subject to the national law. However, the Convention did not particularly mention about the copyrightability of irreligious work, which is against public policy. After reviewing all the relevant laws regarding the copyrightability of irreligious work in Malaysia, it can be said that the laws in Malaysia still suffers from inadequacy in the law. The loophole can be seen in the definition of the irreligious work itself. The Copyright Act 1987, which covers all the work produced in Malaysia, also did not interpret the definition of irreligious work clearly. Therefore, it was suggested that Copyright Act 1987 be amended and give the clear interpretation of the irreligious work as well as its copyrightability. In our opinion, irreligious work should not be protected as the work is against the public policy, and the consequences of the acceptance of such work to be protected under the law should be considered wisely. It is because if such work is protected under the law, it will encourage authors who are skeptical of any religious belief to create more such work. In the nutshell, every person must respect others' religion and belief, and allowing the protection of irreligious work could not in any way be helpful in achieving prosperity among the citizens in Malaysia. Thank you.
Copyright Act 1987 doesn't unequivocally decipher and interpret the definitions of the seditious work or the only wording of seditious. Nevertheless, we can observe and discern that Section 2 of the Sedition Act 1948 clarifies that the term seditious refers to any act, speech, words, publication, or other means that have a predisposition toward seditiousness. So diving in depth into the Copyright Act 1987, it has explicitly reflected that with the silence on the subject matter on the seditious per se. So by cross-referring to Section 2 of the Sedition Act 1948, we can deduce that any works enlisted in Section 7 of the Copyright Act 1987 as aforesaid, that the act, the speech, or words that are able to be published in tangible form or material form, as long as it has the seditious propensity, are considered as the seditious works. Inevitably, as one of the fundamental liberties, freedom of speech and expression has also been guaranteed under Article 10, Clause 1, Paragraph A of the Federal Constitution. Nevertheless, the freedom of speech and expression has its very own confined statutory boundaries that must not be infringed upon. It is bound to the proviso under Article 10, Clause 4 of the Federal Constitution, which elaborates that one's freedom of speech and expression may be hindered if doing so would jeopardize the security interests of our nation and the preservation of the public order. Section 4 of the Sedition Act 1948 provides that any act of seditiousness is unlawful and punishable. It is clearly accentuates that it is illegal to print, publish, sell, offer for sale, distribute, reproduce, or even import any seditious materials, in line with Section 4, Subsection 1, Paragraph C and Paragraph D of the Sedition Act 1948. Moreover, we can have a look on Chapter 6 of the Malaysian Penal Code on these seditious matters too.
My name is Shagamari Munyan and my matrix number is 280365. Obscenity is a term that is most frequently employed in a legal context to define the expression that offend the widespread sexual morality of the period. It has been both used formally and informally with a sexual connotation for a long time. According to the Obscene Publications Act 1959, it has the tendency to corrupt the minds of people. It also a definition which is known as glamorizing potentially dangerous behavior. There are three main tests for the obscenity. The first one is the Hickling test, which was found in the case of Regina against Hickling, 1868. The legal test for what constitutes obscenity in the United States considered a work to be obscene if any portion of the material had a tendency to deprave or corrupt those whose minds are open to such immoral influences and into whose hands a publication of this sort may fall. Secondly, the Roth test, which was found in the case of Roth against United States, 1957. The appropriate test for obscenity is whether to the average person, applying the contemporary community standards, the dominant thing of the material, taken as a whole, appeals to the prurient interest. Thirdly, the Miller test, which was established in the case of Miller against California, 1973. In this case, the material must meet all the three requirements if it's to be ruled obscene. The first is, the average person applying contemporary community standards would find that work, taken as a whole, appeals to prurient interest. Secondly, the work depicts, in a patently offensive way, sexual conduct specifically defined by the applicable state law. Thirdly, the work, taken as a whole, lacks serious literary, artistic, political, or scientific value. According to the First Amendment to the United States Constitution, some forms of expression are not protected at all, and others are protected to a lesser extent, resulting in less restrictions on the government. It appears that the Supreme Court has only ever denied First Amendment protection to obscenity, regardless of whether it is detrimental to individuals, in order to defend the social interest in order and morality. While the First Amendment generally does not protect obscenity, the Supreme Court has made an exception for the freedom to possess such material in the privacy of one's own home. Works are considered to be protected by the Copyright Act 1987 on the basis of Section 7, Subsection 2, which states that this is regardless of the quality of the works or the reason to which they were made. These clauses show that the copyright law in Malaysia does not restrict the copyrightability of works on their subject matter. Rather, a work is copyrightable if it is both original and fixed in some tangible way. However, Article 3 of the Federal Constitution states that Islam is the religion of the Federation, which condemns pornography as a kind of fahisha, which is known as shameful deeds, regardless of whether the content is unpleasant to the viewer. This concludes that obscene works are not eligible for the copyright protection.
Lastly, the majority of the legal jurisdictions do not have copyright statutes that refer to moral requirement as a prerequisite in a clear-cut manner. Despite that, the Copyright Act 1987 doesn't contain any provisions that specifically address the copyrightability of immoral, irreligious, seditious, and obscene works. But the creators should avoid creating works that are either directly in violation of the laws or that are generally recognized as immoral, irreligious, seditious, and obscene. It is also teeming with myriad real risks that the works of this nature will eventually end up weakening the public morality. Therefore, work that is immoral, irreligious, seditious, or obscene should not be eligible for protection under Copyright Act 1987 to safeguard the public policy as well as the morality. Thank you.